Good morning, New York City. This is episode 2 of the Slarskey LLC video series on litigation funding. In this series, we explore hot topics in the area of litigation finance. Today's episode focuses on litigation funding in intellectual property, with a particular focus on patents. I'm Evan Freed. I'm a partner at Slarskey LLC. We are a New York-based litigation boutique. I've had a footprint in the litigation finance space for over 15 years. Among other areas of dispute resolution, our firm represents clients in an array of legal ethical disputes and investment disputes, and very often those matters touch on litigation funding and legal finance. We're joined today by the one and only Larry Rosenberg of Westview Capital. Larry, thanks for joining us today. Could you give a brief introduction on yourself and Westview?
Sure. Westview is an investment fund focused on investment in intellectual property in a variety of structures. We do IP acquisitions, law firm and portfolio financing, patent litigation funding, patent-based lending, and even tailored equity investments. In terms of my background, I started as an investment banker at Merrill Lynch and kind of fell into the patent monetization business while managing a team over at GE Capital, which financed the acquisition of patent portfolios from other companies and then used GE's licensing operation to optimize the value of those assets. I've worked for a specialty finance company, securitizing ongoing royalty streams for patent owners. I ran a patent monetization company which used both licensing and litigation to generate revenues for its investors. I've also served as an expert witness for damages in patent litigation and litigation funding disputes, both at BRG and CRA. At Westview, I'm responsible for sourcing, diligencing, and executing transactions. Given my expertise, I pay a lot of attention to the reasonable quantum of damages in an acquisition or in a litigation funding, just to be sure that there's an attractive enough returns for the law firm, the patent owner, and ourselves.
Great. So it sounds like you've touched just about every single aspect of the space, from buy side, sell side, consulting, testimony, the whole shebang.
Indeed.
Cool. Well, look, we often talk about commercial litigation funding, and a good portion of this series is focused on commercial litigation funding. And that's a relatively new thing here in the United States. How about patent litigation finance and funding surrounding intellectual property? How new is that, and particularly as compared to general commercial litigation?
Yeah, I'm going to say it's been around for maybe 15, 20 years. I started my patent monetization company in the 2008, 2009 timeframe, and there were definitely patent litigation funders available, although certainly not the number that we have today, nor the number of assets under management that we have today. But there's a reason for patent litigation funding to exist, and that's because patent litigation has been accurately referred to as the sport of kings. It's the costs of patent litigation are exorbitant for litigants, and it creates an opportunity for investors to provide cash to litigants or attorneys to fund their cases in exchange for a portion of any awarded damages.
Yeah, for sure. I mean, when I think about investable spaces, you think about scale. Is one of the reasons patent litigation finance attractive from an investor's perspective? Is it the sheer scale of the budgets and the effort that goes into these actions?
Yeah, absolutely. Because patent litigation is expensive, risky, and lengthy, it creates opportunities for tailored investment structures, to mitigate risk and generate returns, particularly when the funder has a portfolio of different matters with diversification. Recently, litigation insurance has become more prominent in the patent litigation business, with products that allow a funder like myself or a litigant to hedge its risk. So I would say the addition of insurance has made it an attractive investment area as well.
Yeah, for sure.
But like in all cases in commercial litigation funding, diligence on the front end is critical.
Hmm.
And a patent acquisition or litigation funding never gets better than the initial review. It always gets slightly worse. So you have to do your homework on the front end.
Yeah, for sure. Well, I mean, we've already touched on a little bit of this. We have litigation finance, acquisition finance, insurance. I mean, it seems like the means of deploying capital in the litigation finance space and in the patent space particularly are growing exponentially. Walk us through a little bit, not just the conventional litigation finance, but the other ways that institutional capital could be used to get a piece of a patent monetization one way or another.
Sure, sure. So away from the kind of traditional litigation finance and patent acquisitions, which we look at a lot of those types of opportunities. We've recently actually looked at some royalty securitizations. As I
Hmm.
mentioned, way back in my background, I actually worked for a specialty finance company that did just that. Securitized ongoing patent royalty streams and
Hmm.
gave an upfront um, amount of capital to the patent owner. So we're actually looking at some of those. And the other, one of the other aspects of litigation funding in the patent space is that not only can you provide capital for the law firm's fees and for the acquisition of the patent assets as well, but also in some cases we provided funding for operations
Hmm.
and certainly funding for future patent prosecution. So, if we're acquiring a portfolio, we definitely want to have the funds necessary to increase that portfolio and its effectiveness. So we fund that type of thing as well.
Sure. And it seems like um, there's one size for everybody. There's different shapes and sizes. Certainly there are the investors who want the high risk opportunity, high risk, high reward. But I guess on the securitization side, are we talking about yields in the teens? What type of cost of capital are you looking at in those types of transactions?
Yeah, again, really, really depends on the nature of the obligors in
Hmm.
those securitizations. Who has the patent owner licensed those patents to. But yeah, generally, I think you're going to be in the mid to high teens in a product like that, and certainly with patent-based lending, I think you're in that same neighborhood in terms of yield, depending on whether there's insurance there or not.
Got it. Great. In this next section, I'd like to shift and talk a little bit about some conflict in patent litigation finance. I'm sure everybody would like to think that this is all roses, but it's certainly not. Conflicts do arise in the patent litigation finance space, and I want to talk about some of the issues that have come up recently and some of the controversies in this space. The first is the IP edge matter that's been percolating for the past year or two. Why don't you walk the audience through what I'm talking about with the IP edge matter and what the controversy is there?
Sure. So in this case, three LLCs affiliated with IP Edge filed patent infringement lawsuits in the District of Delaware against news publishers and IT companies.
Hmm.
The patents that were asserted by IP Edge came from France Brevet, and they were assigned to these three LLCs, which were created at the direction of IP Edge. Judge Connolly, who was presiding over this particular case, had two standing orders on initial disclosures in patent cases, and this is back in 2002, where the name of every owner, member, and partner of a party, proceeding all the way up the chain of ownership, until every party with a direct or indirect interest had to be identified,
Mm.
and the identity of any third party litigation funder had to be identified as well.
Ah.
So in 2022, These three LLCs that were affiliated with IP Edge failed to comply with Judge Connolly's standing order. And that caused the judge to realize that the asserted patents were indeed linked to IP Edge. And in a hearing last year, the judge found that IP Edge purposely maintained a separation between the LLC owners and the lawyers who represented those LLCs.
Mm-hmm.
And further testimony showed that IP Edge was entitled to 90% of the plaintiff LLC's recovery. So Connolly has since then brought in the Justice Department, referred some of the law firms to the Texas Supreme Court, among other things.
Got it. I mean, it seems like, the argument for Judge Connolly's standing order is clear. Transparency, to understand the real party and interest. What's the other side of that argument? What's the argument that, who owns the patent or whether a litigation funder has an interest in it really doesn't matter to, the underlying patent litigation?
Yeah, I mean, this really almost gets back to the whole patent troll debate.
Mm-hmm.
In my view, who the owner of a particular patent shouldn't matter. A
Mm-hmm.
patent owner has rights through ownership of that patent and should be able to pursue them. And what type of owner that is should not matter, nor should any kind of financing that patent owner may have engaged in
Mm-hmm.
be necessarily disclosed. So I think those standing orders are a bit of an overreach, but we'll see how that pans out in the District of Delaware.
Yeah, walk me through or walk the audience through the patent trolling debate and what's kind of gone on over the past, let's call it 10 or 15 or 20 years with respect to what we like to call the swinging pendulum of patent trolling.
Sure. So back in 2011, the American Invents Act, AIA, was created by Congress to presumably protect businesses from patent trolls.
Mm-hmm.
They formed the PTAB as a post-issuance review process of patents. And since 2011, I think the right statistic is the PTAB has found 84% of the patents it reviewed unpatentable.
Mm.
So listen, there are bad actors in every industry, including in the patent monetization business. But what's interesting about attitudes about patent litigation funding is that most people don't think that it encourages unmeritorious cases to be brought, but instead actually makes good cases better.
Sure.
And again, this goes back to the diligence on the front end that I talked about before. We're we're not going to risk our money or our investors' money on an unmeritorious case. It makes no sense. I can't say that that's true for all commercial disputes that benefit from litigation funding, but certainly in the patent world, that isn't the case.
Yeah, sure. I mean, only the best cases are passing diligence, and one could argue that litigation funders are actually keeping the bad cases out of court by being so selective. What has struck me in looking at the IP Edge dispute and the patent trolling dispute more generally is the litigation finance community's support for some of the actions of Judge Connolly and weeding out the more peripheral actors and question behavior in this space.
Yeah, no, I think that's right. I mean, we certainly don't want bad actors coloring the entire industry, and I think you're right. I taking a more balanced view on Judge Connolly's standing orders, I think it probably does help in that regard.
Sure. Let's change focus for a second and look at the Origna matter. Walk us through the dispute between Origna and its litigation funder, and why do we find this interesting?
Sure. So in this case, Origna, which is a plaintiff associated with Atlantica IP,
Hmm.
brought a number of cases in actually in a number of jurisdictions, including district court and the ITC.
Hmm.
Last December, Arigna sued Longford. Longford, a litigation funder, provided $23 million towards Arigna's portfolio lawsuits and was going to pay nearly $7 million of Sussman Godfrey's fees, Sussman representing Arigna in these actions. Last month, BMW, one of the defendants in the Arigna litigation, argued that Arigna should be forced to turn over its litigation funding documents that had been disclosed in error in the action brought in December, in the case that was brought against them in the Eastern District of Virginia. And they further opposed a motion by Sussman Godfrey to withdraw from the action. So it's a really interesting case, largely because Longford's litigation funding agreement was disclosed in error there.
Yeah, it's super interesting. I mean, compare this to maybe the insurance space where contracts are largely standard and you see these, there's a long history of these disputes in court. You don't see a ton of disputes involving litigation funders in court. In your experience, do you see most of these disputes to the extent that they shake out? Are they in arbitration? Is that why we're not seeing a ton of these things?
I think that's right. I mean, in a lot of these agreements, there is an arbitration provision.
Hmm.
And for reasons like we've just seen here, most of the parties don't want all the details of their financing arrangements, available to the public, for good reason. I mean, that's, as a litigation funder, that's kind of your special sauce is how do you structure investments in these types of actions.
Yeah, for sure. I mean, from my perspective, the practicing lawyers, they acknowledge that disputes occur as part of the tripartite relationship, and to the extent that they do occur, I think there's a strong sentiment against airing dirty laundry in public. One thing I've observed is that, having litigated some of these disputes, the arbitrators out there, retired judges or practitioners, tend to be rather astute with respect to these issues, and they really have a strong understanding of how litigation finance or patent monetization or these types of issues, how they shake out, and what this new terminology and the business of law actually means.
Hmm. Yeah.
Um, So, what type of impact has the dispute between Arigna, the claimant, and Longford, its litigation funder? How has that impacted Arigna's relationship with its attorneys?
Well, in this case, as we saw, Sussman Godfrey wants to withdraw from representing him. And because again, because of the mistaken disclosure of this agreement, I think it's put counsel in a tough spot here.
Sure, I guess maybe not a conflict per se, but it could be a potential conflict in that the attorney at the end of the day is the beneficiary in many ways of the litigation funding. And if there's a dispute with the funder, and especially if they were the ones who introduced the claimant to the funder, that could present certain conflicts that an attorney might not want to touch.
Absolutely.
Got it. And you said earlier that BMW has moved to compel certain of details concerning the relationship. How do defendants typically react when they get a whiff that there might be litigation funding involved in a particularly from a patent holder that doesn't have separate operations?
Sure. Yeah, in this, I think in this instance, BMW believes that there's information in those documents relevant to potential damages. Um, there may be information about how much was paid to acquire the patents, for instance, and understanding the investment that Longford had made may have some bearing on what the potential damages are as well.
Got it. Well, Larry, look, we've talked about a lot today. We've taught, you have a long history in the litigation finance space and in patent monetization. You walked us through a lot of that earlier on, and the swinging pendulum, the good and the bad of litigation funding. What are some of your predictions for the intellectual property and patent monetization space for the next few years?
I think we're going to continue to see corporate divestitures of patent
Mm,
portfolios, like we saw from BlackBerry and Intel a couple of years ago. That certainly creates opportunities for investors like Westview Capital. Um, I think it's really hard to predict what's going to happen with Congress and potential litigation. Potential legislation. Um, but we are cautiously optimistic that we're going to continue to see attractive opportunities. I think on the patent lending side,
mm.
particularly with some of the insurance products that we're seeing, I think that's going to be an area that will continue to grow.
Great. Well, Larry, thanks again for joining today. I really appreciate it. And thanks for the audience for tuning in today. Thanks.
Great talking with you, Evan. Thank you.